Welcome to the Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge Allegra Collins. To my left is Judge Allison Riggs. Assisting us today is Senior Deputy Clerk Eddie Sanders and Officer Richard Remillard. On the calendar this afternoon, we have GrayMediaGrp doing business as WBTV versus City of Charlotte on appeal from Mecklenburg County Superior Court. Council ready to proceed? Sure. And have we reserved time for rebuttal? Yes. Okay, how much?
5 minutes.
5 minutes? Okay, great. Go ahead and proceed.
Thank you, Your Honors. My name is Caitlin Gurney. I'm with the law firm of Ballard Spahr, and I'm representing GrayMediaGrp, doing business as WBTV. This case is about one contract and one case, Wamak Newspapers versus Kitty Hawk, from this court, and the willful failure of the state's largest city to follow the plain language of either. In the process, the City of Charlotte threatens to eviscerate one of the finest public record statutes in this entire country and have presented a playbook for other municipalities, smaller municipalities, to do the same thing. It's a two-part playbook. First and foremost, do your business with a private contractor and put the records that you do not want the public to see in the hands of that contractor. The second part presumes that if you indeed have a requester who can afford to sue, then after that lawsuit is filed, serve a Rule 45 subpoena and make sure that you can argue that the matter is moot. That's precisely the circumstances we have here today. We got here by a series of choices by the City of Charlotte. First and foremost, it was the City of Charlotte's choice to do business with a private contractor, and not just any private contractor, one of the largest private contractors in the country, Ernst & Young, the consultant. Trying to help its city council get along better, it engaged Ernst & Young for a lesson in how to get along a little better, and sent surveys to all of the city council members, which they filled out pursuant to a hyperlink. So the city council members themselves were filling out these materials and sending them to Ernst & Young, which Ernst & Young retained for the purpose of their work product. It was also the City of Charlotte's choice when they received a public records request from David Hodges of WBTV for the records, both the contract and the survey responses. They granted the request for the contract itself, which will figure prominently in our discussion here today, but denied the request for the survey responses, saying that they didn't have possession of them, and so they were not public records. This litigation ensued, and after initial motion practice and some discovery, WBTV moved for summary judgment. And then it was the City of Charlotte's choice, once again, instead of immediately responding to that motion for summary judgment, they served a subpoena on Ernst & Young. And Ernst & Young immediately responded to that subpoena, no objections, no motion practice, and produced precisely the public records that WBTV had sought in the first place, albeit 16 months later.
So question, Ernst & Young created this questionnaire, correct?
They did, Your Honor.
And then there was a hyperlink to allow the council members to fill it out, correct?
Correct, Your Honor.
So where were those records actually made? I would assume they were made on some server that was not inside, I don't know, town hall? Did it reside on Ernst & Young's server?
Your Honor, as I understand it, I'm sure the able counsel for the City of Charlotte can clarify, the city council members used their own computers to fill out these surveys. So while our discovery didn't exactly go to where they were or on whose server it was at the precise time, they were using their own computers to fill out these surveys that then went to the cloud and then went to Ernst & Young for processing.
So it doesn't matter where the survey resided?
I don't believe it does, Your Honor. Even under some of the, we do have one case which the city has cited, the Durham Herald case, which talks about possession and receipt of a third party's records in terms of when they became public. Now, the Wamak newspaper's case distinguished the Durham Herald case and said that's about one statute. But if you look at the Durham Herald case and when that, it talks about when something becomes a public record. And it's that receipt of the materials from the third party and the action upon it by the city officials that would make it a public record. So under that Durham Herald case, the act of filling out the receipt and then the filling out of the surveys would take all questions out of it, and it would indeed be a public record at that time.
So even if a council member were to go inside Ernst & Young's physical office and fill out a paper survey, at that point, is your contention that it's still a public record?
Well, that's an interesting question, and one we actually don't have to reach because there is a contract that makes it so extraordinarily clear that every part of the work product of Ernst & Young, except for certain intellectual property that we don't believe to be at issue here, is indeed public record.
Well, and that leads us to the question I have, which can the parties by contract decide what's going to be a public record?
Well, I think here we have an issue where that was decided. We both have action that demonstrates what is a public record through the receipt, through the filling out by public officials of materials sent to them. And then we just have pure possession by Ernst & Young. And case law from this court demonstrates that possession is not part of it. But, so I would argue, Your Honor, that were we to have that before us, it very much, all of the actions here demonstrate that we had a public record created, separate and apart from the contract. But we have the contract that goes above and beyond anything necessary to underscore that this is city property. We have it twice said, where it says exclusive city ownership, twice. We have, if you want to look at the contract, it's section 6, explicitly states city, that's even the heading, city ownership of work product. Then section 8 restates that yet again. And section 8, quite notably, underscores that when the city requests the work product created pursuant to the contract, it will be immediately provided. We have no evidence here that the city ever requested this. Instead, and then we have section 8 also repeats that this is a public record, it's the city's property. And then section 10, again, taking an even extra step, says that the materials are going to be subject to the Public Records Act. So we have this contract that is extraordinarily clear, even if the actions themselves were not clear, which we would submit they are as well.
Let's assume for a moment that the contract and the wording of the contract doesn't create or determine whether it's a public record. I want to go back to my question. If a city council member were to have gone inside Ernst & Young's building, answered a questionnaire designed by Ernst & Young, and left it in Ernst & Young's possession and walked out, is that a public record?
I believe so, Your Honor. I believe when you have the business and city government city government has to act through its officials. So when you have something that is for the city's work product, but for city business, and you have them doing the public's business, no matter where they are, even if it is on the grounds. It doesn't have to be in City Hall. The question is whether it's related to the public business, and are they acting in their official capacity, and are they creating a record? If so, the Public Records Act would suggest that is indeed the creation of a public record. Again, underscoring that this court has been very clear that there is no possession element that's part of the Public Records Act. As you know, and we're here today, the Superior Court did not agree with us. There was a three-part ruling in October 2022, finding first that the case was moot because WBTV had received the records that it sought, even though it was 16 months later. Secondly, denying WBTV's summary judgment motion and granting the city's motion despite the finding that it was moot. And third, denying WBTV's request for its attorney's fees, despite the fact that it had indeed obtained the public records by virtue of filing this lawsuit. And unless the court has further questions, I'll address each of those in turn. All right.
Please go ahead.
Thank you. So first and foremost, the Superior Court erred because this case is not moot. This court's case law demonstrates that how you determine whether a case is moot is you look to the complaint. And if you look to the complaint, or rather the amended complaint here, WBTV has not received much of the relief it sought. As page 137 of the record indicates, there has been no writ of mandamus ordering compliance with the Public Records Act. And there has been no declaratory judgment that the Ernst & Young surveys are public records as defined in the Public Records Act. Even if that weren't enough, this case does, as several cases demonstrate, fall into an exception to the mootness doctrine, which is it is capable of repetition but evading review. And that's a two-part inquiry. First, we take capable of repetition, which Judge Archie of the Superior Court did indeed state in her order, denying, finding that the case was moot. She said that it was capable of repetition. And indeed, the city in its briefing has conceded this and appears to suggest the same circumstances could happen yet again. And we don't have to imagine them. If you look at the brief filed by the amici, there's examples of cases of fine reporting that's been done where the records were obtained from third parties. Even in Charlotte, with the city of Charlotte, there was a reporting by the requester here, Mr. David Hodges, related to the Charlotte City Transit System, CATS, which is entirely in the hands of a private contractor. We don't have to reach very far to think of being right here again. Even further, we have cases, and our briefing is full of them, such as Boney Publishers, News and Observer versus Coble, Beaufort City Board of Education, the Cumberland County Hospital Systems, in dealing with the Public Records Act and other statutes, such as the Open Meetings Law, where this court construes the statutes liberally and finds that indeed the mootness exception here to be applicable. And in terms of the evading review part of the doctrine, it's not about time, as the city's briefing suggests. It is indeed too short to be litigated anytime we have the potential, as we do here, that we had these kinds of cases are always going to be subject to a Rule 45 subpoena because they involve a third party by their inherent nature. And whether that subpoena is filed immediately upon the filing of a lawsuit, which of course, again, takes resources, and the idea of our Public Records Act is that that shouldn't be needed in the first place. Or it could take 16 months, as it did here. Nor is this an advisory opinion.
Can I go back to the two specific requests for relief that you say that you didn't get, which makes this case not moot? So you talked about this writ of mandamus.
Yes, Your Honor.
Could the court actually file a writ of mandamus or enter a writ of mandamus in this case? You already have the records, right?
Right, but that...
And who are they going to, who are you going to mandate?
Well, if you look to the case that we cite all over the briefing in this matter, the Womack newspaper's case talks about the nature of mandamus being extraordinarily appropriate in public records cases. And that goes to because that's a future action. Here we have the city of Charlotte refuses to acknowledge that this is indeed a public record. So we have future conduct at great risk of also being at issue here, and again, being right back here before. So I do believe a writ of mandamus is appropriate. If you look at the News and Observer versus Coble decision, there's also a discussion there distinguishing between declaratory judgment and a writ of mandamus, and the idea that they are two separate types of relief that you can seek in a Public Records Act case.
So you want the Superior Court to order the city of Charlotte to do something in the future? Like, should this arise again?
To follow the law, yes, Your Honor, I do. I think we have the willful failure to follow the Public Records Act. And then the second part of that we never received a ruling on is whether these are in fact public records, these surveys, precisely the question you were asking about, even separate and apart from the contract.
And a declaratory judgment ruling would, in theory, resolve this issue, at least some subcategory of it, of what is or isn't under the Public Records Act, so that in the future, when a good government group or a media group is trying to get access to documents under the public records, there's no longer we're withholding because we don't believe this is a public record.
Precisely, Your Honor, because if you look, since the initial requests and initial letters between lawyers in this matter, we had both sides citing Womack newspapers versus Kitty Hawk, which would suggest that there is some, while it's an excellent decision, it would suggest that there is some room for clarification. The city has latched on to there's two parts of Womack newspaper's decision that the records were in fact subject to the Public Records Act. We've focused on the second part of that. The city has focused on the first, which we believe to be irrelevant here, which is a test for whether, what is a public agency. Here we are not contending, we do not want to contend that Ernst & Young is a public agency. Here we would argue that by virtue of this contract, what we have is the only public agency here is the city of Charlotte. And so then we go to the second part of that, which is extraordinarily clear in very strong language. This court declares that it would eviscerate the Public Records Act to have this idea that you could put public records and public's business out of bounds by putting them with a third party. And so because of that, yes, there is some room in Womack newspapers. We believe it to be quite clear, but I suspect this counsel for the city of Charlotte will tell you it's clear the other way and cite some other decisions, such as the SELC decision, which we simply do not believe to be relevant here because, again, we are not suggesting that Ernst & Young is a public agency.
Can we go back to the trial court's determination that while this is likely to repeat, it can be fully litigated in the future? I know you're disclaiming time as a relevant factor, but assume for sake of arguments that it is a relevant factor. In this case, there was some delay, it seems like, with just normal, complex civil litigation. Isn't it, after you'd filed the complaint and in the course of getting a scheduling order, I mean, you could have issued a Rule 45 subpoena to Ernst & Young, couldn't you have?
I suppose we could have, but that's also, I would argue that if we had to do that to get the records WBTV sought, we have already gotten a denial pursuant to the Public Records Act. Because if you look at 132-6, it states that public records are to be produced as promptly as possible. So promptly as possible would have been right when we received that contract in March of 2021 upon our initial request. And so no matter what, even if there had been that, if we had been the ones to issue the subpoena, which again, we do not believe we had to be those ones, if we had done that when we filed suit 3 months later, that's not as promptly as possible, and we believe would have already been a denial. And the city has repeatedly suggested that WBTV should have brought Ernst & Young into this litigation, and respectfully, or that Ernst & Young is a necessary party, that we should have been the ones to subpoena them. And we respectfully believe that that's a straw man. It is not what the Public Records Act is about. And that would get us to decisions, case law. Perhaps then we would reach SCLC in questions of who is and isn't a public agency, but we don't need to reach that because it's so clear, obviously, that the city of Charlotte is indeed a public agency.
Should the trial court have held a hearing more quickly after the filing of the amended complaint? Like, I'm trying to get, is this a statutory problem? Is this the party's problem? Is this the trial court's problem? If the trial court had issued an opinion in, let's say, December of 21, you amended your complaint in November. If they had issued this order in December of 21, would that have been a situation then on appeal, this could have been litigated fully?
I think if you're looking for where the delay took place, there was initial motion practice, and such that we didn't get the ruling on the initial motion to dismiss, which of course found that Ernst & Young was not a necessary party until November 2021. We filed the amended complaint promptly. There was a brief extension, I believe, for the city to respond, and then we did serve discovery to make it. We wanted to find out a little more about the nature of these surveys, and that's how we did indeed find out, the information about the hyperlinks and the like that we received through discovery. I think that was early in 2022, and then we filed our motion for summary judgment in April of 2022.
So it wasn't until discovery that you knew that there was a email with a hyperlink of the survey sent, as opposed to Judge Collins' hypothetical of where you go to Ernst & Young's office and are interviewed there?
I think, Your Honor, we did receive some emails at the time of our initial request, which may have suggested the hyperlink issue there too. In part, those emails were the basis for our original second claim, which was related to the destruction of records, which we believe was quite clear from those emails that were produced. However, it was denied without prejudice, or the city's motion to dismiss that claim was granted without prejudice, and we simply, to focus on the public records issue we have here before us, focused on the claim that was not denied, rather than reasserting the second claim in our amended complaint.
Can I ask you briefly about attorney's fees? So I understand that your argument is you successfully compelled production by the fact that they produced them ultimately, correct? And thus you should be allowed attorney's fees.
Correct.
Would the outcome of this appeal change that? Were we to decide the merits of this case and determine that the trial court did not err?
Well, Your Honor, I think that's an interesting hypothetical, because you could find that the court was correct in its mootness decision, and that would have nothing to do about whether we were entitled to our attorney's fees by virtue of this litigation successfully compelling the production of those records. So I would argue actually that you could affirm the trial court's decision in that respect, but that would have nothing to do with, if you look at the plain language of 132-9, and the language that talks about successfully compelling the production.
I guess my question is, that goes a step further. If we went beyond mootness and determined that the trial court didn't err by determining that these weren't public records?
Well, that gets to an interesting question of the trial court, which never, the trial court did indeed grant the city's motion for summary judgment, but I don't know that the trial court should have done that if they found that the case was moot.
So we don't really know why they granted summary judgment at that point.
Correct. It was simply that the city's motion for summary judgment was granted. So I would argue that there was a procedural error there alone. But returning to this mootness issue, there is a rather clear basis just in 132.9 that if you do indeed find that this matter is moot, which of course we believe there's two full reasons that it is not, but if you should find that, there's still a way to institute the spirit, emphasize the spirit of the Public Records Act, which is in 132-9, and because that's about whether a requester has successfully compelled the disclosure of public records, in which case the court shall allow a party to recover its reasonable attorney's fees. Now, there's no question here that but for the filing of this litigation, there would be no Rule 45 subpoena.
You're going into your rebuttal time.
Oh, all right. Well then, Your Honor, unless you have any questions,
No, thank you.
I will sit down and just note for the record that we do believe that we should have our attorney's fees on top of hopefully a declaration that these are indeed public records, and I will see you for my rebuttal time. Thank you.
Thank you.
May it please the court, Daniel Peterson for the City of Charlotte. Thank you for having us up to oral argument today. Your Honors, it is indisputable that the city did not have possession of the sought records at the time this complaint was filed, and these were records created, to Your Honor's point, in Ernst & Young's web space using their proprietary intellectual property.
Were these surveys filled out on city-owned computers?
We are not sure of that because the plaintiff never instituted discovery to that effect, Your Honor.
Did you have any obligation as an agency with duties under the Public Records Act to see if there were retained copies of the answers supplied by city council members in the course of doing public business on city-owned computers?
Thank you for that question, Your Honor. I think the answer to that is kind of a twofold. I think if those answers resided on a city server, I think that obligation would have existed. Here, one, there's no evidence that it ever did. The issue is...
Well, but I guess
Yes,
what
Your
I'm
Honor.
asking you is, you say there's no evidence. I'm asking you, did you have an obligation to look to see if in the cookies or in the history of the city computers that they retained this information?
Typically speaking, Your Honor, it's my understanding that metadata, such as those found in cookies and those kind of things, those sort of, trying to search for the word, the intrinsic cookies within the excuse me, in any event, the
Metadata is a good
metadata,
That's
thank
the
you.
word I-
Thank you, Your Honor. Yes, I got lost on the cookies there. The metadata is not typically seen as a public record in itself, or else we would be subjected to constantly digging into metadata.
Well, so let me ask you, do you have any case that you're relying on for the conclusion that metadata isn't subject to the Public Records Act?
I don't have a case, and it's not in my briefing, but I do have I know the UNC School of Government has opined on that, and it's in a book by Professor Lawrence, I think it's Bill Lawrence, related to metadata.
Well, so let me pose a hypothetical, right?
Yes, Your Honor.
Technology is changing. Would it be legal for the city under the Public Records Act to, for security purposes, say we're going to do all of our notes and emailing not on city servers and not using city email, but we're going to contract with this storage company or online security company and have all of our emails and our correspondence hosted there to keep it super safe, and the city council members will only have access to it for a couple of days, and then we don't have it anymore. Would that comply with the Public Records Act?
Such as a cloud technology, if I may ask, Your Honor? Sorry,
But it's a cloud technology, but I'm getting to, where's the line between what you're suggesting is we can contract with all of these other parties and have city council members doing city business on city dime, do all this work somewhere else, such that we can say we don't have access to it. Where does that stop? Like here, it's a survey for, community building, team building, but what other city business then does that open the door to? Or where's the line for me to say that that isn't a slippery slope?
I think in this case, Your Honor, it's because it just was a link that was on the city server itself, and that they clicked through, again, using Ernst & Young's data. However, to directly answer your question, I do think the cloud technology would be still a public records, it would be a public record. I think the case law would be clear that you can't just house it somewhere else for the purposes of obscuring it from the public record, Your Honor.
So is your distinction here the difference between being cloud-based and Ernst & Young's server?
I think that's right, Your Honor, specifically with the fact that in the contract that opposing counsel references, and we cite in full block quotes, talks about the proprietary nature of this particular data. So the court doesn't have to reach the writ large situation where we've got, and I'm sure that's already developing today as technology develops, where we're housing, for instance, Microsoft or Google's, cloud technology. That's a different situation from what we have here, where emails that were literally typed out by city council members or the city attorney, et cetera. Here we've got, in the contract itself from record page 143, a discussion of proprietary data, methodologies, processes, and that the subpoena that I issued to Ernst & Young responded explicitly, making it clear that it was because of the narrow phrasing of said subpoena that they responded at all. And then two, they marked the production confidential. Now, they did not seek a protective order, so under Rule 45D1, I had an obligation and did so the same day, turning it over to opposing counsel.
So I got a few questions from there. First is, I understand the law is once something's been sent to a governmental or an agency email or mailbox, that receipt is what triggers the creation of a public record. So I guess my question is the fact that it was a hyperlink as opposed to a survey sent, is that critical to your analysis?
I think it is, Your Honor. And kind of going to this, to again, kind of we've got the facts here to where does the slippery slope stop? I do think it is important because kind of going to the question Judge Collins had about a city council member going and filling out a survey, a hand survey in Ernst & Young's offices. Would that city council member, would the law require that city council member to take a photocopy of it with them before leaving the building? And I just don't think it does. I don't think the Public Records Act envisions that. Perhaps the Public Records Act needs some updating from down the street, Your Honor, for these types of issues. However, I think because it was a hyperlink, and to use that analogy, here, that would have required city council members to screenshot their responses and save them. That's a separate act. What they did was they opened this hyperlink, answered the questions, and the questions themselves, to be clear, are Ernst & Young does these kinds of surveys nationwide, and I would posit that those would be part of their proprietary and methodology data that they've developed, that they reserve as confidential, that under our public records statute, the proprietary data exception exists.
The answer that city council members gave,
Yes, Your
in
Honor.
their own words, on the taxpayer's dime, that's
Created on the city.
created on, sounds like at least possibly on city computers. That's Ernst & Young's proprietary information?
Well, I think it's these were primarily, not all, primarily multiple choice answers that you're clicking on. And then there were a few open-ended questions, is my understanding from the production. However, I do think that the way the tool that Ernst & Young has developed does kind of pretend these methodologies as proprietary. But then also under the Womack decision, the Ernst & Young, and under the SELC decision, Ernst & Young is not an agency of the city, such as a city attorney's office, would be wherein Kitty Hawk, they hired a private law firm to be their duly designated town attorney.
So say the city, on that, so say the city hires Joe Smith, court transcriptionist, to transcribe a public hearing you're having in North Charlotte. And you say, Joe Smith, I want you to transcribe verbatim what happens at this public hearing, what we say, what they say. City council members are here on the public dime. And we believe that this will be a public record. And then Joe Smith forgets to send you the transcript when it's done. If plaintiffs in this case come to you and say, we want the transcript from that hearing, do you have an obligation to say to Joe Smith, give me my work product, give me what is a public record?
I think in that situation, Your Honor, the answer is that the court transcriptionist still has the record in that
Right,
situation.
that's what I'm saying. Just
Yes, Your
like
Honor.
Ernst & Young has the answers here, it's something you paid for, you wanted. It's during the transaction of city business, but you don't physically have it, but you own it. You paid for it. You paid the bills.
I don't think so, because there is a possession requirement in our statutes, or in our jurisprudence rather, that you are allowed under the State Employees Association case that possession, while not needed to be pled in a public records complaint, still is a defense to the Public Records Act. And again, going back to, we heard about choices in this case, plaintiff could have put Ernst & Young as a defendant in this case and obtain the same, such as in your example, Your Honor, the court reporter would then be on in the eventual complaint.
Is there such a thing as constructive possession?
Generally speaking, yes, Your Honor, in the,
Okay, so Charlotte, the city of Charlotte could be in constructive possession of the documents that are in Ernst & Young's physical possession, because they actually have a contract to have that information, correct?
yes, again, again with the proprietary data exception that I've already discussed.
So if we talk about the proprietary data, is there a difference between what's done with the answers to the questions that come from city council member and whatever bar graphs and recommendations that you all make? Seems like one is what the city council member said, and the other is what you do with it, and that's the proprietary part.
I think that it's not the city's proprietary part. It's, I think, again,
Ernst & Young's.
Ernst & Young.
Let's say, so it's their bar graph, right? They created some sort of deliverable with
Yes,
the
Your Honor.
answers, correct?
Yes, Your Honor.
But the city council members actually answered, and that's the public record we're talking about, correct?
Well, I think the question, though, and the answer, I mean, you could.
You say that the question, by virtue of how the questionnaire is put together, is proprietary. That's your argument?
Yes, Your Honor,
Okay.
it is. And in this case, I think it's important to note that, again, these types of proxy fights can be avoided by having a third party in the litigation itself. They could have been avoided by getting the documents, the plaintiff getting the documents originally in itself. And I think that that's a critical distinction here, Your Honor.
But I think, go ahead.
Oh, no, give.
No, I was just going to say, it seems to me that the large issue is whether the city can keep its documents in the possession of a third party and shield it from the Public Records Act. I mean, that's the question we're trying to answer, right?
I think that's part of it, but I also think, again, we're talking about the Womack decision with there being an agency in play here, Your Honor, and the SELC decision where the North Carolina Railroad is owned by the state and was not deemed to be a state agency and thus not subject to the Public Records Act.
Well, would you agree that the Public Records Act was to promote transparency, governmental transparency?
Yes, Your Honor.
Okay, so what is it, wasn't the city in possession of these responses right before the city council members hit send? When it's on a city computer, they're answering this, they've completed the survey, right before they hit send, did you have possession?
Assuming they were on the city network.
Even once you hit send, you can still pick it up in the send, whatever bin.
Well, respectfully, Your Honor, I don't think so in this case. I think it was because it was a hyperlink that they clicked. They didn't respond to an email. I think this
Okay.
would be different if the city, again, responded, or city council members responded to said email. I think, again, they're being directed to Ernst & Young's web space was the issue here.
Okay.
Yes, Your Honor.
Do you, I mean, I'm still struggling with, in particular with this hyperlink. I mean, help me find a grip for a limiting principle here, because I'm imagining a lobbying firm, of law firms sending hyperlinked surveys to legislators or to city council members, and essentially like asking for positions that the voters are entitled to know about. And under your argument, particularly with the information goes back to in my hypothetical, the lobbyist server, and it's a hyperlink, not an attached survey. I'm having trouble finding any distinction between these two, and the latter seems to run really counter to the spirit and the letter of the Public Records Act.
I think that's a legitimate concern, Your Honor. But in deciding this, Your Honor, I think we've got the initial question of the mootness matter as well. If I may, I don't want to cut off any questioning, but the fact is that we proceeded with, we had an original complaint filed in June of 2021 that contained a lot in it, Your Honor, to put it politely. And the city felt, the 15 defendants at that time felt that we needed to pursue the motions practice that we were very successful in, except for one part of the complaint, the first claim for relief, that we've been primarily discussing at this juncture, Your Honors. And then we had to file a motion to strike because there were references to memes. There was an accusation that the city attorney destroyed public records. He was named as a defendant. So we had to go through the motions practice and that original complaint. And then only at that, the plaintiff was directed to file an amended complaint excising these allegations, and then going forward from there, and kind of to address the court's question during plaintiff's time was, plaintiff did not put the matter up for hearing immediately after an answer was filed, wherein we did plead lack of possession. There was no subpoena at any time during that buildup to Ernst & Young. There was no motion for judgment on the pleadings, for example, filed by the plaintiff. We filed the motion to dismiss, and at that point, we had to narrow the issues at play, and that resulted in the November amended complaint. Where I'm going with that, Your Honor, is that this, while it is possible that this is repeatable, and I would still posit that this is not the situation, we've only had the hypotheticals at this point, that those issues can then be fully litigated later because the procedural timing, speed matters in these mootness cases. The procedural issues in this case were completely of plaintiff's own creation. And so the issues before the court can be fully litigated the next time around to the extent that this is even repeatable. And excuse me if I may just pull a page up here. And the cases cited in our briefing emphasize the point that all those cases were mootness. There was a mootness exception here. It was because it was days between the challenged act. The timing was measured in days, not months, and not almost a year as it was here. And so the fact that we were accused of gamesmanship by submitting a subpoena, using the rules of procedure equally available to both parties, should just not be, it just should not be considered here because yes, Your Honor.
Well, so, I mean, isn't that civil practice generally? I mean, you're under an obligation representing your client to engage in whatever motions practice necessary to narrow the issues, being respectful of the court's time, which is much appreciated. When is that not going to be the case under a Public Records Act case? I mean, so what's the enforcement mechanism if plaintiff files a motion for judgment on the pleadings and tries to get calendared, and you say, I need some more time to respond to the amended complaint? Not saying that's unreasonable, it's fairly normal. Need some more time to respond to the complaint. Need to issue we have a scheduling order, I want to issue a subpoena. All of those things take time, and so what's the enforcement mechanism to avoid this repetition in the normal structure of civil practice in this state?
If I understand the court's question, please stop me if I'm not responsive. In this case, it was completely avoidable. There were photographs of the mayor described as a meme in the complaint. This wasn't typical motions practice.
No, and I mean, okay, so the motions practice ended after the amended complaint. I guess that my question is, from the amended complaint on, I know there was a delay or a request for an extension to respond. There was some discovery on, it sounds like, both sides. And maybe all the motions practice was done, but all of what I just described takes time, and if there's an urgent issue, I'm trying to figure out, is this the court's error, is it the plaintiff's error, or is this something where the way that the need for urgent information is just at conflict with the pace of civil practice?
Thank you, Your Honor. I understand the question now. The pace is, there's a provision in the Public Records Act that talks about setting it for the court shall set it for, I think maybe immediate hearing may not be the word, but something, priority hearing or something to that effect. And there are procedural mechanisms that plaintiff could have, whether it was a motion for judgment on the pleadings or just a motion for expedited discovery or a motion for this, that, there are procedural mechanisms within Rule 26, et cetera, that within Rule 45, that this could have been brought quicker instead of, and the discovery we're talking about here, Your Honor, and if I'm not mistaken, and the record will correct me if I'm not, was served pretty quickly with the original complaint. It was actually part of the protective order during the pendency of the original complaint. So we had responded to the discovery pretty quickly thereafter, either before or shortly thereafter, responding to the amended complaint. And to be frank, we most of the time when, for instance, in my practice, as often in the defense side of it in a civil practice, if I file a motion for summary judgment before the discovery deadline, the first response is, well, Your Honor, discovery's not closed yet, kind of thing. And so from my perspective, I was just kind of like, okay, what's next, kind of thing. And that's where I was, candidly a little surprised that there wasn't more discovery into the very questions this court has asked about what is Ernst & Young's position precisely on the proprietary data. And I'm kind of in the position of making almost Ernst & Young's argument for them and somewhat of a proxy situation. And that's where I think I hear and certainly understand the court's concern about the slippery slope, but on the flip side, the slippery slope here, and I think this goes back to why this can be fully litigated the next time. The slippery slope here is, why is the public agency being put into a proxy fight with a requestor?
Well, had you requested the information from Ernst & Young?
Prior to the subpoena, Your Honor?
Yes.
I had not.
So, you may have avoided having to be in a proxy fight with Ernst & Young by just requesting it.
Well, I think Your Honor is correct, but the response from Ernst & Young suggests that it may have been a proxy fight, because they did say, you know, I've got the language here, if I may bring it up. Find it in my notes here, that they marked the documents confidential, and they said the narrow subpoena phrasing obviated the need for them to do objections. And then they reserve the right of, hey, if you mean anything broader than what we're giving you, marked confidential, we reserve the right to further object. So I think that predicts a proxy.
Doesn't the city or any public agency have an obligation under 132-7 to keep public records in a place that are safe and relatively easy to access for public inspection? So I guess to your arguments about, well, this is a proxy war and it's on the city and that's not fair, isn't it with the city making the decision to have Ernst & Young send these hyperlinks and not share the response in an easily accessible way, with that, and then not just asking them, I mean, if you can narrowly write up a subpoena, you can narrowly write up an ask. It seems like these are not, while a proxy war issue might be something we'd be concerned about when it's a problem of your own creation by these two choices, and you have an obligation to keep public records in a safe and accessible place under the statute. Explain to me why the proxy concerns overcome that.
Well, I think here it would be, in that scenario, Ernst & Young's responsibility to keep them in under 132-7. However, Your Honor is correct that if it was the city's obligation, then under 132-7, that is the depiction, that is the statutory mandate, Your Honor.
Does the city have an obligation to even ask for the document?
As unsatisfying as it may be, Your Honor, I don't think the statute contemplates that ask, particularly in the situation where we've got, again, and I hate to be a broken record, but this sort of pre-existing IP situation that the court has asked me about.
So as long as everything's responded to in hyperlink, then no governmental agency will have to produce it in a Public Records Act request, right?
I think only if it's, again, if I think if there was only this IP concern, Your Honor. I think that if it's not, I think in kind of going to the cloud kind of example, I think that situation doesn't arise here because I don't think that's an IP issue.
Don't you still
So
have,
let's just think if you sent a hyperlink and this is going to go to the IP issue, and although it's not proprietary questionnaire, you use a proprietary type of encryption. All of a sudden you've manipulated it with some sort of proprietary software. And the only way to unencrypt it is with a proprietary key.
Yes, Your Honor.
Are we left with the same situation where we can't get those documents because they're encrypted with proprietary information and we can't use that proprietary key?
Under that hypothetical, I think either whomever has the obligation, either like in this case, the city or.
So this is it's Ernst & Young's server, it's Ernst & Young's hyperlink, it's Ernst & Young's encryption.
I think at that point, they would have the obligation, knowing they're working with a public entity, to go create the record, or to go kind of strip it of.
So Ernst & Young would then own or possess this document, and it would be Ernst & Young's responsibility then?
I think once they've stripped it of the pre-existing IP, one of two things could happen. They could send it directly to a requester, or on the city's demand, give it to.
But your position is then that the city of Charlotte there is no public record any longer once it's been acted upon with Ernst & Young's proprietary software?
I think that they would have an obligation under the Public Records Act to strip it of the pre-existing IP.
That Ernst & Young would.
At Ernst & Young, yes, Your Honor.
So Ernst & Young would have a responsibility under the Public Records Act?
Which is supposed to promote governmental transparency, not transparency of private businesses.
Yes, Your Honor. The tension here, I'm sorry, Your Honor.
oh no, finish your answer.
The tension here being that again, assuming that we get to that under the WOMAC analysis, and I think the question predicts that, that they would then have to abide by the Public Records Act by doing business with the city.
Doesn't the city have an obligation to put that in their contract then? If we received a request under the Public Records Act, then you have to strip it so that we can make this, that we can produce this record. In order to promote governmental transparency, which is what it appears very clearly that the General Assembly was aiming for.
Again, I think that there's perhaps some updating of the public records statute that needs to happen to answer that question.
To account for.
Yes, Your Honor, I do. And I'm not meaning to be cagey. I just think that the text of the statute doesn't, it was written in the 70s, that doesn't predict hyperlinks and proprietary IP. So
You're correct.
Yes, Your Honor, I don't.
I'm a little confused because based on the last two questions, it seems like we were very focused on the IP, and it sounded to me like the possession wasn't an insurmountable barrier. Like, it's either up to the third-party contractor or it's up to someone to remove the IP issues, but the fact that the city doesn't have them isn't a bar here. At least that's how I understood the answers before, but I heard you earlier say city doesn't have them, doesn't have possession.
I think that's part of the situation I find myself in, is that I'm, again, making an argument on behalf of a private entity that I don't represent, and that's where I was really addressing it as the private entity's responsibility. Again, kind of circumventing that first question of agency under the WOMAC analysis and SELC, that then that it's really the obligation of that entity that is elected to do business with the city, not the cities directly. And that, so the possession perhaps is not insurmountable, but it is, but it would then rest with the private entity at that point.
Your time is up.
My time is up.
Do you have any further questions? Do you have any further questions? All right.
Thank you very much, Your Honor.
Thank you, sir.
I appreciate the questions.
Your Honors, we've heard some remarkable concessions during the City Council's argument with respect to that there was no search to determine whether there was any metadata or record on a city computer. That was never made clear, and there is unquestionably an obligation to search. And we also just heard that it was Ernst & Young's requirement to strip of proprietary data and turn over. That is not contemplated by the Public Records Act, but what is contemplated by the Public Records Act is what is in 132-1, which is public records defined. And it states quite clearly that a public record shall mean all documents, papers, letters, maps, books, photographs, films, sound recordings, magnetic or other tapes, and electronic data processing records, or other documentary material. And we also have, in the Public Records Act, the state archives has a job to do in terms of administering the universe of material subject to 132-1. And the state archives has said metadata is indeed public. So we have a statute that was intended to be living and breathing and to transcend technological changes. And we, in fact, have a state archives, and we can provide supplemental submissions if that would be helpful, that is determining how that changes. And there is no question, because we have a lot of decisions on this, that when a public official uses a private email server to conduct city business, that is a public record. There is no question, and again, we know this because we have decisions on it, that when a public official chooses to write a text message to his fellow city council members or to, that is a public record.
I have a question. So the questionnaire that was posed without any answers, was that a public record?
Once it was.
No, just,
Yes.
they wrote it, they put it on their server. As it sat there, was that a public record?
I believe that the Public Records Act contemplates some level of receipt. Now, there could be
So-
a contractual issue there in
I'm
terms
just
of the
talking about-
contract, but I believe you to be asking about the Public Records Act.
That's right.
In which case,
So it's
receipt.
It resides on their server. Now, the hyperlink is sent. At that point, a hyperlink is sent. Is it your position that the questionnaire is now a public record, or is it still not a public record because it's not been acted upon yet?
Your Honor, I actually think that a few materials in the record may be helpful in terms of being able to show what was received here. If you look at page 168 of the record, you can see the way that Ernst & Young sent these materials to City of Charlotte council members. And the notable thing is it was sent in an email and thus received on a city server at a city council person's email address, official email address, no private there.
So when this link was sent, did that then transform what sat on their server that hadn't been acted upon yet? Was that a public record? I'm trying to figure out the line between their proprietary information, what they're saying is the questionnaire, and if that information becomes a public record.
So I would say when the email was sent, unquestionably that email, and I don't believe the city disputes that because we received what is at page 168 of the record as a records request. I believe the moment that city council person clicked on that hyperlink and started filling that in, we have a public record. Because what the Public Records Act contemplates, just the same way the Open Meetings Law contemplates that we should have open meetings, the Public Records Act contemplates the moment the public's business is put into a document, is preserved in some way in a documentary form. And yes, those kinds of documents, as we see, as we've discussed today, are changing every day. But the moment we have a public official conducting public business and creating some kind of record of that, that is a public record. And so the filling out of the clicking on that hyperlink, the filling out of the surveys, and it so happens that we now, of course, have these surveys because thanks to the Rule 45 subpoena and the idea that this was somehow proprietary. These are feelings, these are comments about working with fellow council member. This is the public's business. It's showing how they were getting along with their fellow council members. It strains credulity, to say the least, that this is somehow proprietary of Ernst & Young's. No more. It is simply the vessel for the thoughts that are memorialized from city council members.
Your time is up.
Thank you.
Thank you. That concludes oral argument in this matter. We'll take it under advisement. I want to thank you both for your excellent arguments. Mr. Sanders, we may adjourn.